In some situations, it is possible that the inferior and superior right coincides in the same person, and in such cases, the rights combined lead to the discharge of contract. You have gone ahead, exceeded the rules and regulations, and now you are going to face a monetary damage. You might not be paid. 90% of us do not understand the real meaning of law. Good morning and welcome to the session 5 in Unit 2 in Commercial Law, where we are going to continue with the topic on discharge of contract, the second part of it, where I'm going to talk about discharge of contract by remission. Now, what does the word remission means to us? A promise can waive or remit the performance of the particular promise in whole or in part altogether. He can also extend about the time agreed. So in the example 3 above, the Peter only repays a part of the money, because in the previous session, when we talked about the money that was taken from Peter to John, about 1 lakh rupees, and finally, because he lost his job, he agreed to pay only 75,000 rupees. Now, that 25,000 rupees was waived by John, understanding the situation of Peter, and he agreed to it. So this is where the remission part comes into picture. So in the case of a contract, the parties can come back and waive certain part of the promise, either completely or on a part-by-part basis, saying that, okay, we are taking this particular position and we can take into consideration in terms of the waiving of the particular contract, the remission of the contract. This is not possible every time. This depends on the factor, how we can go about remitting it, why we have to do it, under what circumstances, and all those factors will be looked into it. So that's why I would like to say the remission is a very big challenge. It's a very big factor altogether. Now, moving further, discharge by non-provisioning of facilities. Now, let's look into this factor altogether, non-provisioning of the facilities. Now, in many contracts, the promisee agrees to offer reasonable facilities to the promisor for the performance of the contract. If the promisee fails to do so, then the discharge of liabilities arising due to it will be a non-performance. For example, if I have to perform certain thing, let's say that if I have to build a building, I need certain things for it. If I am not provided with the materials, with the land, with the basic factors that I need, then how will I be able to complete the contract? So when you are giving a contract to somebody, you also need to give a reasonable amount of facility, reasonable amount of infrastructure, amount of factors that can help him to complete the contract. If that is not being given on time, then automatically it will lead to the non-provisioning, then automatically it will go to the no performance in the discharge of contract. So this is very, very important for all of us. So whenever tomorrow, if you are going to sign a contract and you are going to tell your people clearly that this is why we have taken up the contract under these terms and conditions altogether, that means there is something very, very important there. You have to give the person the necessary flow of goods, the necessary flow of the required things, so that you will be able to get the materials, you would be able to get the performance of the contract done. If it is not done, then that leads to a problem altogether. So that's why we go back and say very clearly that the provision, the non-provisioning of the facilities will automatically lead to the non-performance of the contract. Now, the one more thing which I would like to suggest as an example here, Peter agrees to fix John's garage floor provided he keeps the car out of at least 6 hours. Peter approaches him few times, but John is reluctant to get his car out. So hence, John fails to provide a reasonable facility. This contract cannot be done. As I have told you, now for example, I sign a contract with a builder, with a real estate person, and I say that I will be able to construct 6 floors of the building by 1 year. and I say that in this 1 year, these are the materials that I required for him on a timely basis, then only I will be able to complete that building of 6 floors. So floor 1, 2, 3, 4, 5 and the ground floor together. So I will be able to complete the building only if I get the materials on time. But then what happens here is that the person promises, but he forgets or he fails to deliver the respective materials. So I am not able to construct that 6th floor building. Now that is exactly a non-performance of the contract. So it is very, very important for all of us to understand what scope are we talking about today. Suppose we are trying to build a contract out of nowhere. Out of all our thought process, we just come out of the picture and we just try to build a contract saying that this is what I want you to perform. This is how things have to go all together. Then the contract can never ever be established. The contract can never ever be fulfilled altogether. You need to understand this factor very, very clearly. Unless and until you are able to give the respective movement, the respective thought process to that particular level, you will not be able to see it at all. So that's why I always say that you need to see the obligations that are arising. Now the next thing, discharge of a contract due to the merger of rights. Now what is a merger of rights? In some situations, it is possible that the inferior and superior right coincides in the same person, and in such cases, the rights combined lead to the discharge of contract in governing the inferior right. So in case when there is a weak and a stronger position come into picture, a merger happens. That means a combination of the contract happens all together. Then in that situation, then in that circumstances altogether, what happens? We are able to combine the rights together. We are able to merge the rights together. Once we are able to merge the rights together, automatically that would lead to the discharge of the contract. So how is this going to happen? Now, for example, Peter rents John's apartment for 2 years. 1 year, the contract, he offers to buy the property from John, who agrees. They enter into a sale contract and Peter becomes the owner of the apartment. Now you see, there are two things that have happened. Peter initially rents John's apartment for 2 years. So first time, he is a person who is like a tenant. After 1 year, Peter agrees to buy John's apartment, so he becomes a owner. So there are two rights which we are going to see. One accorded by the lease agreement and the second accorded by the sale agreement to the same owner. One is a lease, that's a tenant kind of a thing. The second thing is a owner kind of thing. So both of them are now merging because the parties have agreed and the contract was able to be performed. The discharge of contract is done and then it is taken into position. So the former being an inferior right, it's a lesser one being a tenant. The second being a superior right because you tend to become the owner of the apartment. So now you will be able to understand, appreciate on the factor that the owner of the person who takes up the ownership, the discharge of contract is being done because of the merging of two factors or two facilities altogether. So that's why I would definitely say here that the merging factors really matter a lot. This is very, very important for all of us to understand and take it forward. This is highly, highly possible because this is how things are being taken into position. The next thing is that in the law of contracts, now we are going to talk about the effective reference. This being a very, very important factor, I would like to discuss it very, very clearly here. Why? Because when you talk about the law of contract, the discharge factors altogether, in the law of contracts, there is an excellent deal of bewildering or the lack of understanding. When I say the lack of understanding in reference to certain topics connected with the topic of discharge. The first thing that I would always like to say here is that 90% of us do not understand the real meaning of law. So when a statement has been made or when an act has been performed or something is being given by the court of law, we don't understand the real meaning of law. We think that law has been established as a personality, as a factor which will only change or charge a person as per the need. The law is only meant to find fault. That's what we believe. Then only the law comes into picture. But unfortunately, law is not meant to find fault, or law is not meant to catch people. Law is meant to guide the people. Law tells that please follow this path. It is beneficial to you as well as to the society. So that's why whenever you get into contract, whenever you get into any sort of agreement thought process altogether, the law helps you to guide. It takes you to the next level. It tells you very clearly that please follow these certain amendments, the acts that have been told. Then there would not be a problem in terms of execution. But 90% of us don't go by it because we don't understand the law. The second thing is that we feel law is not important. Let's not worry about law. We will just go by our own thought process. We'll go with our own ideas altogether, and that's what it leads into a problem. The next thing is that it is a thanks to the fact that very few people use such terms as condition and warranty with the same sense. The words called as condition, warranty, discharge, or when we start using those big terms called as performance, non-performance of contract, has not been used by everybody. Why? Because many of them do not know the meaning of it. Today, if I want to rent my house to somebody, all I know is that there is a rental agreement that is available. I will take that rental agreement which is already existing with some person, try to modify that agreement and give it to my tenant. Now, all I want to know is that whether the tenant will agree and start paying the rent from the first of every month. That's all I want to know. I don't want to enlighten my tenant with the state of law, neither my tenant wants to talk about the rules of the land. So what happens here is that 90% of the time, very few people try to understand the depth of the meaning. They don't go exactly with the terms and terminology. They just believe that yes, law has been taken into position. It has already been considered. You understand it. I also understand it. A lot of assumptions come into picture and we just do about it. We don't go exactly trying to understand what is behind that statement, why that statement has been released, why people are trying to amend, or what is the reason behind it. We do not want to know. Now, the most effective way of discharging a contract is predicated on the performance, and in this manner, both the parties follow all the terms of the contract and afterwards they opt to discharge. The one thing that you need to understand about the discharge of law. Now, when we say about the discharge of contract altogether, the only single way through which you will be able to conquer it, you will be able to do it accordingly, if I have to put in the words exactly here, is by the performance of the contract. How is the performance so much bothered about in the case of law? Because performance is something which is very important here. How do you tend to do certain work? You might tend to do a work because you believe that this is the nature of working. Certain other people might believe that no, performance is not needed. It's already assumed. Yes, I have done it. Moment you told it, I did it. Yes, end of the story. It is done altogether. So what we are trying to enact, what we are trying to see, what we are trying to understand is entirely different. So what we want people here is that we want the discharge of contract purely based on certain standards. That is where it actually matters a lot. I am doing a particular act or I am doing a particular work because there are some standards that is being set, and that's how the discharge of contract is always enabled. Tomorrow, if you are going to take up a job in a company, in the offer letter document, there is something written about your roles and responsibilities. They mention it very clearly that these are the things that you are needed to perform in the organization. That it's exactly like a do's and don'ts. You are not supposed to disclose the Companies Act, or you're not supposed to disclose the company data. There are so many facts that have been written on that particular document. What most of the people tend to do is that in a hurry, in a state of mind, they just go ahead and sign the last page of the paper saying that I hereby agree to the terms and conditions. That is good. But then what is most important is, have you read through the terms and conditions? Why? Because tomorrow, if there is something that you do by mistake, by chance, and then you try to claim your innocence, the company is not going to believe you. Why? Because the discharge of your duties is based on the performance standards that has been mentioned there. So that's exactly where we say that you need to go through, understand the standards of performance, what has been told, why it has been told, why you need to perform a particular activity in this manner. All those things have to be agreed upon 100% clearly. Then go back, sit with your HR manager or the person who has formed that contract, ask him 100 times clearly, what is it all about? Why is this standard being prescribed? Then only you will be able to understand and you will be able to perform your duty much more effective. Followed by, on the other hand, the breach, the discharge of breach is most undesirable thanks to the releasing you from the duties. Why do I mention this? The breach is a common factor that happens across the globe. Many people think that by breaking a contract, nothing is going to happen. I'm not going to be caught by the court of law. Nobody is going to put me behind the bars. All is going to happen is what? I'm going to be sent out of the contract. I don't want to serve this company anymore. I don't want to be associated with you anymore. So I will just walk away from that scenario. This is an escapism route for me. But let us try to understand the breach of contract is an undesirable part of action from your side. We don't want that. Every time if you're going to break the contract and going to do something, it is highly not acceptable. This particular way will not be accepted by any one of us. Why? Because when you enter into a contract, when you expect certain people to perform, the same thing is expected back from you. They say that when you are doing or serving a contract, it is mandatory that you take care of that duties properly. So that is why we say very clearly, it is most undesirable that when you start breaking a contract and when you start saying that, yes, I have understood, but then at the end of the day, you have not completed the contract. The next thing, therefore, discharge by breach leads to damages too. That's very, very important, where there is no instrument which will be considered for the requirement, and then there is a great difficulty in providing execution of the deed, and the requirement itself cannot be physically delivered. Moment you go on the breach factor, because this happens many a kind of thing. Moment you go on the breach factor, moment you try to prove yourself the other way around, there is not going to be a physical damage, but there's definitely going to be a monetary damage that is going to happen. Now that is something which is not acceptable by both of us. So what happens in a breach of contract is that you have gone ahead, exceeded the rules and regulations, and now you are going to face a monetary damage. You might not be paid, or you might have to compensate back. There are a lot of other factors that might come into picture. So it is always advisable that you please follow the contracts to the last letter and word that has been written, and you maintain the integrity and sanctity of the contract. Please do not try to go back, argue and say to the other person that the contract is being done in this way. I have understood it. I have assumed certain things. Let us not go by assumptions. Assumptions lead to problem. So in a discharge of contract, we say that please surrender in terms to the law so that it will be easy for you. But here, the surrender or cancellation of evidential documents may even in these latter cases prevent proof of duty, or it's given as an evidence of mutual rescission. Sometimes what happens is that this breach of duty goes to that extent. Now people start asking you the proof, people start asking you the evidence, people start asking you 1001 questions about it. Now that's the time when you will start thinking about the proof, about the evidence. Where did I keep the document? Did I really sign up like that? Was something written like that? No. So the problem here is that very, very clear. Problem starts because you didn't follow the rules or you didn't understand the rules. So moment you get a contract, moment you have been asked to take charge of a contract, understand the line, read between the lines, understand the meaning, and then start signing up the contract. Why? Because tomorrow the same evidence will be taken against you and they will say that, sir, you had signed up for this, but today you are taking a step back. So it's always important that you sign the contract after reading and after understanding the contract word by word. Now, the next thing, when we go to the conclusion factor, the rescission and substitution are interwoven into one body or one breath, neither one having the power of separate existence. So it's a mutual thing. That's what we talk about a contract. At any given point of time, contracts are interwoven in nature. One has to perform, the other also has to go with it. So at any given point of time, I will go away, you will go away, we will try to do something different is not the matter that is accepted here. What is accepted is that there cannot be a separate existence factor at all. The existence factor comes because there is a mutuality, there is a thinking factor here. Both of them have accepted, have agreed to perform this. So on pleading such a discharge, the defendant must allege the exact same things that have been alleged by the plaintiff, by the person who sues upon the contract, except for the indicate of a break. In case if there is a break in the contract, in case there's an alteration of the contract, I have gone ahead and altered myself with the mutual consent of the parties, saying that I am not okay with these terms and conditions, then there is going to be a factor, or else definitely by not following the rules, you are going one step closer to the court of law. The defendant isn't seeking a remedy and hence he must not establish the existence of any secondary obligation, and he must allege merely the agreement showing that it includes a rescission of the previous obligation. No technical language is required, absolutely not. Why? Because when you are talking about a mutual contract altogether, it is plain. It is simply written clearly that this is what the contract is. Moment the other person tries to go away from the contract, trying not to perform, trying to take away the scenario altogether, you don't again have to go about using a very complicated language, trying to seek bigger proofs or identity. All you need to do is that go back, take that agreement as the plain evidence and start proving it. Why this happened? Why did that person go back? With this, I come to the conclusion of this particular session. I hope and believe that all the information shared through this particular session will be of a great help and resource to you. In the upcoming session, we shall learn more about the remedies of breach of contract. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.